I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask. And you know what? Let's not have any more children.
Yes, ma'am.
Until we're ready to have more children, until we have our own place, okay?
Yes, ma'am.
So how are you doing?
Good. Oh,
well, I mean, not good because you're seeing me. How old are you?
21.
So I'm going to give you a choice. You only have two choices. But either choice you choose, you're going to be taken into custody today. And let me just tell you why.
I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party.
Welcome back to the courtroom where things just got awkward fast. We're looking at Jesus Santoyo, a 21-year-old father facing a second-degree felony. But did you catch that voice from the gallery? Someone tried to pull the sovereign citizen card, claiming the court has no jurisdiction. Pro tip: interrupting a judge with legal theories you found on a conspiracy forum is the fastest way to get a front row seat in the hallway. Now, let's see if Jesus can keep it more professional than his friends in the back.
So if you're not consenting to this court's jurisdiction, sit down.
Did you understand the state is proceeding on the lesser included offense of possession with the intent to deliver a controlled substance? Penalty group 2, 1 gram to 4 grams. It's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, if the court wishes. We will waive a pre-sentence investigation.
All right, anything you wish to say on behalf of your client?
Judge, Jesus is the sole provider of his family. He has struggled with back pain since the automobile accident, and he was using in this THC and marijuana derivatives for those purposes. He understands now he's going to have to manage his pain with a doctor, a different doctor, whichever one that's going to help him. And he'd like to continue working. He's supposed to be promoted in his job on his birthday in December. We would ask that the court follow the plea bargain. He also understands that the TAP evaluation could recommend any sort of drug treatment, and he would be, of course, willing to abide by whatever those recommendations are of the TAP evaluation.
All right, hey,
Excuse me, ma'am, I couldn't really.
I'm sorry, who's Alma Sotelo?
That's my mom, ma'am.
All right. So this was at your mom's house?
Yes, ma'am.
Who else lives at the house other than you and your mom?
It was, at that time, it was just my dad and my little brother.
And how old is your little brother?
At that time, he was probably like 16, I believe. Because he's 2 years younger than me.
So where are you? Are you living there still or living somewhere else?
I still sleep there sometimes, but I don't right now, or I sleep here with my baby mama. So I like kind of go back and forth.
No, you're sleeping at the household of the mother of your child.
Yes, ma'am. I'm sorry. I didn't mean to say disrespectful or nothing like that.
That's okay. No, I mean, if that's the mother of your child and you love your child, it's the mother of your child.
Yes,
it's not
yes,
your
ma'am.
baby mama.
Yes, ma'am.
So do you only have one child?
Okay, let's talk legal stakes. Jesus is looking at 2 to 20 years for possession with intent to deliver. That is a massive window. The judge is being unusually patient here, even giving him a mini lesson on respect by correcting his use of baby mama. You can feel her trying to gauge if this kid is a criminal or just a young guy who made a massive mistake and needs to grow up. But the question is he actually ready to be a man, or is he just telling the judge what she wants to hear? What do you guys think? Is the judge being too hard on him or just right?
Yes, ma'am.
How old is your child?
She's barely going to go 10 months.
Okay. So why are you back and forth between your mom's house and the mother of your child's house?
Well, because she stays still with her mom and stuff. So like they don't mind. I'm pretty sure they'll let me move in, but I just don't feel like comfortable like staying with them like that. So I go back and forth. Like, I'll spend the night here, like I'll spend the night with them. But then again, I'll still go back to my house and I actually stay there.
Well, things have changed. When I was growing up, Brenda, my mom would not have allowed that. So
yeah, that's my parents are old school Mexican parents as well. So they weren't really too fond of idea.
But don't let your son do that.
Yeah, yes, ma'am.
All right, so how are you supporting yourself?
Right now I work at 2 Men in a Truck. It's a moving company. I'm looking at a promotion when I'm 20. That's the only reason I'm not a driver yet. The company policy, you have to be 20 years old. So right now I get paid $13.75, but once I get promoted, they'll bump me up $3, so I'll be at $16.75.
Okay, so did you graduate from school or no?
Yes, ma'am. From John F. Kennedy High School. I graduated in 2020.
So what are you planning on doing with the rest of your life? What are your hopes
my
and dreams?
first goal was to go be either in the HVAC industry or to be like an electric. But then I got my girlfriend pregnant, all that happened, so I had to get a job sooner than later.
All right, if you're drug tested today, is it going to be positive?
Yes, ma'am. I'm not gonna lie to you. I was at work still before, I still smoke with my coworkers, or either that, or they'll have the new thing called Delta 8, and I know for sure that still has some THC. So I know it's still pop up. I'm pretty sure.
And there it is, the moment of truth. Jesus admits he's going to test hot for THC and Delta 8. In a courtroom, honesty is usually the best policy. But when you're on the verge of sentencing for drug charges, admitting you smoke with your co-workers is a bold move. He's leaning heavily on the I have a job and a promotion coming defense. It's a classic strategy. Prove you're a productive member of society so the state doesn't want to pay to keep you in a cell. Will it work?
Still pop up like that.
All right, you're going to have to stop using, you understand?
Oh, yes, ma'am.
So what are your work hours?
Right now I go, I have to be at work by 7:30, but then the time I get out, it just varies on my job. Sometimes I could get out as late as 10 at night or as early as 12 or 1, just depending on my job that day.
So when you're saying 7:30, is that 7:30 p.m. or a.m.?
Yes, ma'am. 7:30 a.m.
They have you working from 7:30 a.m. to 10 p.m.?
No, well, that just it just depends on your job, ma'am. You never know, it could blow up on you. The latest I've ever stayed there at job or that I got back to the warehouse was at 11 at night.
Okay. All right, so this is what the court is going to do. The court is going to follow your agreement, sentence you 4 years deferred adjudication, $1,500 fine probated, restitution of $60 to Bexar County Laboratory for drug testing. And we're going to do field visits, random one time per month.
For that, ma'am, did y'all want it to my house or my?
Oh, we're going to discuss that in a minute.
Oh, good.
All right. It's going to be proof of employment within 15 days, no employment as a home health care provider or with minors. All right. With regards to your housing situation, you need to choose a place that you're going to live. So it really, here's the thing. Her parents really shouldn't be allowing you. This is me speaking to you as someone who is concerned, right?
Yes, ma'am.
Her parents really should not be allowing you to come and use that place as a hotel because that's what it's being used for. Some days you're there, some days you're not there. And she shouldn't even be allowing you to use it as a hotel. So
yes,
if
ma'am.
you all are going to be a family unit, then it needs to be a family unit where you all have your own place without you spending some time there. I don't think this is Dallas with Norfolk where everybody has their own wing, right?
Yes, ma'am.
And I know
yes,
I'm aging myself by saying that, but let me make it better. This is not Buckingham Palace where everybody has their own apartments within the palace, right?
Yes, ma'am.
So you need to make a decision on whether or not you're going to be living with her or whether or not you're going to be living with your mom.
No, I'm going to live here then. If that's one in Northern, I'm going to live here then.
Well, should you really be living there though? That's my question.
Don't get me wrong. I still come after, as soon as I get off work, this is where I go. I come here, most of the time I'm always here. But I wouldn't say that I live here.
But you shouldn't be using a place as a hotel. Let's be honest. You're using that place as a hotel.
Well, that's my goal, to get our own place, but you can't just speak it. You got to make it happen, I guess.
Yeah, you do. And so the way to make that happen sooner is to stop using that place as a hotel Because as long as you have a free hotel, there really is no reason no incentive to get your own place, right?
Yes, ma'am.
I mean,
Well,
that's
my
just the
daughter's
way
my
it is.
incentive. My daughter's my incentive to get home.
Yeah. So, I mean, you got to be your own man. And part of being your own man is getting your own place for you and the mother of your child if that relationship's going to work out.
Yes, ma'am.
Okay.
The judge just hit him with the hotel metaphor, and honestly, it's savage. She's calling out his lack of stability. It's rare to see a judge give this much life advice, but she's trying to show him that as long as he has a safety net, his mom's or his girlfriend's parents' house, he'll never feel the burden enough to stay clean. She's basically saying, grow up or the state will grow you up in prison. Do you agree with the judge? Should she be giving life advice or just sticking to the law?
Hey, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Santello, what I'm telling you is what I would tell my brother, what I would tell my cousin. And if the mother of your child were my relative, I would tell her, don't let him come over here using this place as a hotel. Tell him, you know what? If we're going to be together, we need to get our own place. And it's not a hotel room. It's not for him to just come and sleep and whatever. You know what I mean?
Yes, ma'am.
Because your child that you have, you're supposed to be raising them so they won't tolerate that. And they don't think that that's the right thing to do.
Yes, ma'am.
And her parents shouldn't be allowing that either.
Yes, ma'am.
And it's an apartment, right?
Yes, ma'am.
And how many bedrooms is that?
2.
Oh, no. That would never have been allowed with my mom. And I guarantee you, everybody who's on this screen, including
No,
your
it wouldn't have
attorney,
been allowed. Don't get me wrong. My parents, they're old school Mexican parents. So they're like old school parents. I'm talking about like no girlfriends, couldn't bring no one over, like it's the house type stuff like that.
well, you can't bring anyone over if you're going to use the house as a hotel room. But I guarantee you, even your attorney, his parents would not have allowed that.
Yes, ma'am.
Am I right, Michael Velichek?
That's right, Judge. And I know also that I believe he needs to help with his mother and with his child. So when you get your own place, you need to stay close to everybody. Can you do that?
Oh, yes, sir. Well, that's what at first we're trying to find something by my work, but then income's coming around the corner, so we were just gonna wait for that,
Okay.
get both of our monies in.
All right. And you know what? Let's not have any more children
Yes, ma'am.
until
Why
we're
not?
ready to have more children,
Yes.
until we have our own place, okay?
Yes, ma'am.
All right. I wouldn't tell you this if I didn't care. All right. I'm going to send you to breakout room number 2, and probation will meet you in 2, and they'll go over conditions and make sure those levels go down. All right.
No, yes, ma'am, of course.
Judge,
So how are you doing?
Good. Oh,
Well, I mean, not good because you're seeing me. How old are you?
21.
All right. So here's the question for you. You are on deferred adjudication. Do you know the range of punishment for your offense is up to 10 years up to 20 years in prison? Do you understand that?
Yes, ma'am.
All right. So the question you have to ask yourself is whether or not you're continuing to use is worth going to prison for 20 years.
No, ma'am. And I have another kid on the way as well.
Then why kids or baby goats?
I have another child on the way.
So why are you continuing to use
Well,
drugs?
In the beginning, I'm not gonna lie, it was hard, and I was clean for 3 months. Then I slipped up at a function, and then
What function is this where people are smoking marijuana?
it was just for a fight. So it was really just me, my friend, whatever.
What fight?
The one with what's his name? Honestly, forgot, but it was a fight.
So you're going to a fight and you don't even remember the name of the fight, but that's worth you potentially going to prison for 20 years.
No, it wasn't worth it, but I just had slipped up that day. And then it takes a while for me to get clean. It took 3 months for me to actually get clean. So I slipped up then.
All right, they're asking that you go to SATA.
That one?
Yeah, they're saying that you need to go to SATA.
What is that? I'm not.
That's inpatient treatment.
I don't think, because I know I could stop. I stopped for those 3 months. Like I said,
Yeah, but you didn't do well. I mean, you're stopping for 3 months and you're looking at going to prison for 20 years and then you continue to use. This states the defendant admits he is addicted to marijuana.
Yes, ma'am. Like I said, in the first year, I'm not gonna lie, it was hard, but I finally stopped doing it. Like I said, I just slipped up. I thought it wasn't really gonna be like it was gonna stay in my system for that long because it wasn't a lot. But then it's like
Because you thought you would get away with it.
not get away with it, but I thought I'd just get it out of my system.
Yeah, that's you thinking you would get away with it. If you're thinking it's going to get out of your system before you test it. When you drug tested today, what the result's going to be?
I'm not sure. But I still come out a little bit dirty. Like I said, it took almost 3 months for me. When I actually stopped doing drugs, it took 3 months because that's when my PO said I finally came out clean.
Your Honor, may I?
Yes.
The last drug test that was done on 4/25 was positive for THC.
And do we have levels or no?
I can check it, Your Honor.
All right. So this is what I want to do with him. He's going to do weekly testing, and it's going to be through the UA hotline. He used to be tested for levels. If those levels go up, we're not going to have another compliance hearing. It's going to be a motion to revoke filed. Do you understand?
Yes, ma'am.
And I'm going to want him to retake intensive outpatient treatment. And if it's not ordered, I did order parenting classes. Have you completed
Yes,
parenting
ma'am.
classes?
Yes, ma'am.
You didn't learn anything from it.
Oh, I did. I mean, I don't do it. It's not like I do it in front of my kid or like do it in the house.
A kid is a baby goat.
My child.
Well, here's the thing. The fact that you're doing it outside your house, you can't tell me that you don't come back into the house smelling like marijuana.
Oh, well.
Let me just tell you right now, I don't drink alcohol at all, but there is someone who came in this courtroom who smelled of alcohol. I don't know who it was, but it nearly knocked me out.
Yes,
So the fact that you are using marijuana, your child knows that you're using marijuana. And guess what? Children are going to end up teasing them because they're going to come to wherever they come to smell like marijuana. And if you have a child that's on the way, I guarantee you that mother is probably using marijuana, messing up her baby's brain. And when marijuana is used in the household, it messes with the baby's brain development. These are critical years and critical times for infants. Their brains are developing. They're soaking up everything. That's why they're super intelligent. When children use profanity, they get that from their parents or whoever's around them because they repeat everything. The fact that you're using marijuana, whether you think they know it or not, they do. And you're going to send your child off to school smelling like marijuana so other children can choose them about their pothead parent. Do you understand?
Yes, ma'am.
So you're going to get your life together. If those levels go up, what's going to end up happening is a motion to revoke is going to be filed, and you're going to be looking at 20 years in prison, and you're going to be possibly going to prison for 20 years. And people ask you why you're here, you're going to end up having to tell them because you wouldn't stop using marijuana. Your time in prison wasn't worth you giving it up, and your children were not worth you giving it up. Do you understand?
Yes, ma'am.
And stop having children until you get your life together.
Yes, ma'am.
All right. So he's going to retake IOP as well. Is there anything else you need from the court? And don't go into any more fights, especially if you don't know the name of the people.
Yes, ma'am.
And honestly, boxing hasn't been great since Sugar Ray Leonard and Muhammad Ali. People don't even have skills anymore.
Yes, ma'am.
So, all right. Thank you.
Wait, did we just transition from a 20-year prison threat to a breakdown of 80s boxing and Seinfeld episodes? This is the Judge Valia Mays experience. She uses these pop culture detours to humanize the court. But don't let the Seinfeld talk fool you. She just reminded Jesus that he's one slipped up joint away from losing 2 decades of his life. He claimed he smoked because he was watching a fight he can't even remember the name of. Talk about a bad excuse. If you were the judge, would you buy the "I just slipped up at a party" line?
Luis, do y'all have an agreement or no?
I got a recommendation. I believe that defense is asking for slightly less.
All right. Court is calling 2021 CR 3906 State versus Jesus Santoyo. Could I have parties announced for the record?
Jason Garrett for the state, Your Honor.
Jonathan Watkins for Mr. Santoyo. Good afternoon.
Good afternoon. And are you Mr. Santoyo?
Oh, yes, ma'am.
How do you pronounce your last name?
Santoyo.
Santoyo. Okay. Sorry, I can't do the accent. I'm doing the best I can. All right. So defense has filed a motion requesting that a bond be set. You are on deferred adjudication. Is that correct?
Yes, ma'am.
So you're entitled to a bond. The only issue is what that bond will be set at. All right.
Yes, ma'am.
And states you're prepared to proceed.
Yes, Your Honor.
All right, and state, what are you requesting for a bond amount?
$15,000, yeah.
All right, and defense, what are you requesting?
Judge, we're asking for 5,000, and the reason we're asking for that amount is based on he has dependents, he works, and Judge, I asked him to show up this morning. He did show up this morning. We came back at 1:30, but he's wanting to handle this.
Right. All right. Do you want to call him as a witness with regards to bond amounts?
Just briefly, Judge.
Sure. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jesus Santoyo.
All right, you may proceed, counsel.
You're aware as to why you're here.
Yes, sir.
Okay. And how many children are you supporting right now?
2 kids.
And do you live here in San Antonio? Very nice.
Yes, sir.
And do you have a spouse?
Yes, sir.
Okay. Are you the primary person responsible for paying the bills?
Yes, sir. I'm the only one that works.
What kind of job are you doing right now?
I'm a driver for material transport, so we deliver doors and building materials for houses and stuff like that.
And is that a job that you're working 5 or 6 days a week at?
Yes, sir. From Monday to Friday.
Okay. And based on your current situation and being the primary supporter of those children, what kind of bond amount would be something that you and your family could afford?
The lowest possible just to help us out. To make bond.
Nothing further.
All right. So I have questions to ask you, and it's relating to my setting a bond amount. Have you ever been diagnosed with any type of mental health issues?
No, ma'am.
Ever been on any type of medications? In the past, have you ever used any type of drugs?
Yes, ma'am. Just marijuana.
All right. So, and here's my other question. This is not for you. This is just for attorneys. Part of the issue I see in the motion to revoke, and I'm not taking it as true, there's an assault case. Is that a misdemeanor assault?
Yes, ma'am. And he has a bond set at 5,000 on that one. It was 2,500, and then it's.
And which court is that out of?
So, Judge, it's out of County Court 13, and I tried to go there to just get them to reinstate the bond, but the DA couldn't agree to that. So,
all right. So I'm trying to figure out County Court 13. Is that family violence?
Yes, it is.
All right. So who is the complainant?
It hasn't. May I speak, ma'am? It has nothing to do. It wasn't a family member or nothing like that. So we don't know why it's family. But
No. Here's the thing. Don't speak about any of the facts. I'm just trying to figure out who the complainant is in that case.
Yeah, it was just some guy. You know.
and the information we have, judges, it was just a guest of the home that day. And actually, Your Honor, just to make things very clear, I haven't reviewed the discovery. I don't want to speak on the case. From what I have been informed, that person was arrested for aggravated assault. So there were 2 bookings in one.
All right. So does anybody have a name?
It was Valentino Vasquez. That was it.
Valentino Vasquez?
Yes, sir. Yes, ma'am. Sorry.
All right. We can go off the record. Is there a way to look the name up?
I could possibly look it up, Judge, if I got a SID or SO or something.
Right,
I
because
just don't have it.
If I said the wrong name, I'm sorry, ma'am. I'm just trying to remember.
No. I'm just trying to figure out who it is because I'll need to do a no contact order. So that's why I need to know.
That's
And I'm going to go into Odyssey and see if they have anything.
Judge, by the way, that's one of my favorite Seinfeld episodes. I believe it's season 8, episode 19, the yada yada.
Oh, yada yada.
Yeah.
You know, one of my other favorite episodes is when Kramer, it's all over the Keys. And so Kramer leaves and he goes to live in the big city, Los Angeles.
Oh, yeah.
And he gets accused of being a serial killer.
Very good, yeah.
And they go visit him at the jail and they ask him, how's everything going? It's Seinfeld and it's George. And Kramer's like, oh, everything is going well. I've had some people review treatments. And they're like, Kramer, you've been arrested for being a serial killer. He's like, oh, nothing. Then he walks out with the guards and he's like, could I have 1 second? And he comes back. He's like, get me out of here. But at the end, they're like, how's it going? He's like, I'm just doing what I do. That's the way I've always done it. That's the way I always do it.
Yes, Judge, this is, I can't remember who said
Okay,
that.
thank you.
That's who's listed in the MAG paperwork and everything.
All right. So we're back on the record. The court is going to set your bond at $8,500. Court is calling 2021 CR 3906 State versus Jesus Santoyo. Can I have parties announced for the record?
Rick Pena for the state of Texas.
And Jonathan Watkins for Mr. Santoyo.
And are you Mr. Santoyo?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Jesus Antonio Santoya who was placed on deferred adjudication in 2021 CR 3906 for the offense of possession with intent to deliver a controlled substance, penalty group 2, 1 gram to 4 grams on November 15th, 2021 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, on the state's original motion to adjudication of guilt, violation of condition number 21. On or about the 22nd day of March 2024 in Bexar County, Texas, the defendant, Jesus Antonio Santoyo, did then and there fail to comply with the instructions of Bexar County Supervision and Corrections Department intensive outpatient treatment as directed by the head or authorized personnel of that agency, and that the defendant failed to comply with the program requirements in violation of condition number 21.
How do you plead to that? True or not true?
Well, true, ma'am.
State will waive the remaining violations on the original motion to enter adjudication of guilt as well as the violation on the first amended motion.
Any objection?
We have no objection to that, Your Honor.
All right, did you understand by pleading the violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
It was 20.
I'm sorry?
It was 21.
He was 21? What are you saying?
I believe you said violation
Condition.
condition 1 and.
Oh, I'm sorry.
Yeah, it was condition 21.
Great, thank you. I was speaking very quickly. Let me, Cindy, you appreciate them slowing me down. All right. Did you understand by pleading true to violation of condition number 21, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 21?
Yes, ma'am.
Court will find violation of condition number 21 true. All right. State, what are you requesting?
Your Honor, we're asking that this defendant's probation be extended for 1 year, that base conditions be altered and amended to include local ISF followed by ISP.
All right. And defense, what are you requesting?
And Judge, just so the court is aware, I do want the court to know that a drug court referral was made the last time we were present. I did speak to the CLO, and I believe that he wasn't able to do drug court because they were at capacity.
Yes.
What we're respectfully requesting, Judge, we're on the same page with the state for pretty much the whole agreement. We're just asking that the ISF be held in abeyance. And I do want the court to pay attention to the history here. The history does not look good. Okay? I just want to be straight and out in the open with that. But I have encouraged him to attend NA meetings. He maintains to me that he has given up smoking altogether. He has a 4-year-old and a 2-year-old, I believe.
Yes,
He's 23, Judge. He's about to be 24. I'm not trying to excuse any of his misconduct, but I think that that fear of God has struck him. He is scared here today. And Your Honor, we'd be willing to do weekly reporting and weekly UAs for however long the court would impose. So I'm asking that the agreement be for the extension of probation for 1 year, Your Honor, and respectfully, if the court were willing to give Jesus one last opportunity at this, I'd ask that he be given zero tolerance, weekly reporting, weekly UAs, and that the ISF be held in abeyance. That's what we're asking.
All right. Probation, what do you recommend?
Judge, recommendation on the court summary is within 1 year in the local ISF followed by ISP. I would like to know that would be resolution of the union.
Take care of that.
So what is happening with the new offense?
More than likely going to be asking ATIC to reject the offense.
Okay. So he's saying that he's going to, the state will address the new number 1. So that will not be an issue.
We'd also just ask for her to take judicial notice of the entire court summary.
All right. Any objections to the court reviewing the court summary?
No, Your Honor. And
So I'm going to give you a choice. You only have two choices. But either choice you choose, you're going to be taken into custody today. And let me just tell you why. One, probation has been working with you since 2021 for you to stop using. And it's continued over and over again. Or either, you'll have a dilute and then there will be a positive. And then it shows here that in February 6, 2023, you were negative. The 14th, you were negative. Then you failed to submit. Then you failed submit. Then positive marijuana throughout the month of April. And then throughout the month of May, June. And then October, you failed to submit. Then February of 2024, you're positive. And it states here that they did do progressive sanctions with you. So they didn't even send it to me until.
What was that, man?
Oh, that means that they don't necessarily ask for a motion to revoke on you. They take different steps. For example, they may say, he's using marijuana. Let's give him 30 sober meetings to get it in line. And then they'll say, yeah, he's still using marijuana. Then let's do this form of treatment. So they've given you different sanctions so that you wouldn't have to come before me on a motion to revoke. And it hasn't worked.
The only thing I remember doing just the class, if I'm not mistaken.
And then you failed to comply with the instructions of intensive outpatient treatment. I mean, so it's been tried. So I can do one or two things, and it's completely up to you. But as I said, you're going to be going into custody. I can extend you for a year, and I'll extend you for a year, and you'll be taken into custody to do ISP, which is being recommended, or I can revoke you and sentence you to 2 years in the prison.
I'll do the treatment.
All right. So we'll extend for 1 year, deny the motion, alter and amend conditions to include ISP.
Is it ISF?
I'm sorry. Let me see what it says in here. Just one moment. Yes. All right. So it's local ISF followed by ISP. And probation, before he's transferred, if there's an opening in felony drug court, then that can be changed to felony drug court. Right now, they don't have an opening in felony drug court.
Would I have to go in today? Is there any way I could turn myself in?
I'm sorry?
Would I have to go in today, or can I turn myself in just to get stuff situated at the house?
No, you'd have to go in today. All right. And they're still going to be working. And if you'll maintain contact with probation to see if there's ever any openings in.
That's what my inquiry to the court was going to be. Should there be an opening to drug court, would he be able to, would that referral will be in place?
Yes. And the problem is they have a limited number of personnel over there. I always tell people, call your legislature and tell them to give them more money because it's truly a great program. All right. Is there anything else you need from the court?
I just want to I'll keep an eye on the drug court because if that were, is that reflected in your notes as well?
Yes. All right. Is there anything else? All right. Thank you.
Thank you, Judge.
The hammer finally drops. After years of progressive sanctions, basically the court giving him chance after chance. The judge gives him the ultimate choice: a year of intensive treatment in custody or 2 years in prison. Jesus chooses treatment. But you can hear the panic when he realizes he has to go now. No going home to pack. No saying goodbye to the kids. This is a reality of the legal system. When time's up, it's up. Will this be the wake-up call Jesus needs? Or will we see him back here in 6 months? Let me know your predictions in the comments.
And the need for perfection here. This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
Says 19, Your Honor, seven, within that 7 or 8. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that
I'm sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize, sir. Can I please speak on the breathalyzer?
No.
Just
You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Oh, please, no.
No. To his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate and, for
test. And he is blowing outside the window, so we don't know what he's doing.
God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor, I will do anything. I'll even go on that drug, Anklemon. I'll do anything, Your Honor. I'm really trying here. I swear to God, I'll do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor, it's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond?
Of course.
Oh my gosh. Hey, please, I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to use it. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 75 to judge for bond.
Okay, Ben. Okay. Great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not going to do that. I can't. But fine. Because. All right, 7502.
Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, John.
Good morning. State your appearance, please.
Right. Ian Redmond, P70599 on behalf of the plaintiff.
And your name, ma'am?
Judicial Banks occupant.
Pardon?
Judicial Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court
because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
there's more. Go ahead.
There's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that. Okay. I'm not.
The reason that I mention all of this, Your Honor,
go ahead,
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
I vote yes.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and then you can go challenge it. With who?
With Whitlow. Miss Whitlow.
Then you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but.
Well, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting.
You're recanting what?
What I just stated.
Which part?
The part that I stated that I'm not. I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that.
So you are consenting to this court's jurisdiction?
At this moment. Oh.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under false.
Answer and counterclaim to what?
To their complaint for eviction.
You have a lease with, allegedly, with Miss Whitman.
Correct.
Then that is who you need to pursue it against.
Okay. And
or whatever the heck you're doing.
well,
because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
Okay, I'm not really understanding, but
Well, let me put it a little bit more simple. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
Okay.
any claim of your interest in that property, you have to go after the witness because that's the only person you have a contract. Allegedly have a contract with.
Okay. No, there is an actual contract.
I don't know that, man.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so, as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny. And it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, you're stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you.
Okay. Thank you.
I know you didn't.
We'll await. I did.
Oh.
No.
No, I don't think so. I don't know if Mr. Fink is ready.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you.
Send me an email from
If anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also
You went the day before court.
And I also went before.
Judge, she's been going. She's been going before, even the last court date, and we you know,
Prove it.
I think that's.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I got an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, you know, attempt to go to the class. So she's been going. She did already take a test, and this is the one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
I'm trying to teach you.
Texting who?
The instructor. Like, what I'm supposed to show you. Because I don't have no proof. Like, I don't have nothing.
Tell me, what have you done?
I went to the class.
Okay. Which class did you go
The
to?
GED resource.
Okay. And what, because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number because I'd like to call them right now. Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. Sir, I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and reading. Based on that, they go on 2 tracks. And so one track is like a probation station where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED content. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
How long does the process take? And how long can we expect it?
well, so that's honestly kind of a loaded question, depending on where they fall. I believe Courtroom is going pretty well.
Great.
So, yeah, and, I've worked with people that have gotten the GED in 3 weeks. I've worked with people that got the GED in 2 years.
Oh, yeah. I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
No, I understand that.
She's been faithfully attending, though? Yay or nay?
Yeah.
Okay, great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay. So I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got like what he's saying. If you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take
Okay.
care.
You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay.